All right, everyone, good afternoon again, and welcome to the Most Cited Standards and How to Avoid Them, the fifth webinar for Conn Maciel Carey's 2017 Msha webinar series. I will be your host today. My name is Nick Scala. I am the co-chair of Conn Maciel Carey's National Msha Workplace Safety Practice Group. I'm also a certified mine safety professional and work with mining companies and independent contractors nationwide in both Msha contest work as well as compliance assistance, investigation management, and also agent cases and discrimination cases with Msha. So as we get started today, we're going to be discussing and doing a bit of look back on the data on enforcement from the past year, so the 2016 Most Cited Standards from Msha. And this is a very, although can be tedious task to look back and see these standards, it also is good to give us more information as we look towards compliance moving forward and identifying trends on an industry-specific basis. Now what we'll see is that for both surface and underground and metal, non-metal, and coal, that there is obvious trends in what citations are or what standards are issued depending on each industry group. And as well, looking at those who registered today, we're going to focus more heavily on metal, non-metal, because I believe that most, if not all, of the registrants are in that industry sector. But we will touch on coal and some of the most cited standards just briefly. Then we're going to look at defenses. So we are going to find out what these most cited standards were, what are some of our defenses, and what are the proactive steps we can take to prevent issuances under these specific standards. First, it's always interesting to just look at the delineation of operations and how that influences enforcement, or maybe how enforcement reflects on that. So this is a chart that is from NIOSH, and it is outlining from 2006 to 2015 the number of mines in the country. We can see as we're looking at this that the metal non-metal industry makes up about 11,800 mines. So that's about 89% of the mines in the country, which is obviously the vast majority. We can see that also if we're looking at the number of employees for each commodity, it breaks it down more specifically. But if we're just looking at it from a metal non-metal to a coal perspective, that works out to metal non-metal being about 70%, a little over 70% of the miners in the country. Now with that, that is how we're looking today. And traditionally, though, Msha has been a bigger concern for the coal industry, and that can be traced back to the enforcement that the industry received. And if you joined us early in the year for a bit of a look back, you probably recognize this graph from Msha, but it's reviewing the number of citations that have come in and how many citations are being issued based on coal and metal non-metal. And that will, I'm sorry, I just saw that the volume is very low. I've increased the volume, so please let me know if that persists. Thank you. By looking at this chart, we can see that, while there has been a significant decrease in the number of citations issued, that decrease has been primarily related to the coal industry. And if we're looking at the metal non-metal statistics from 2013 to 2016, we can see that the number of citations issued for that industry sector, or for that division of Msha, they've really stayed pretty static in that 56,000 issuances per year range. We've obviously seen a significant drop in what was issued to the coal industry over the last 5 years. And I think that drop is by roughly 40% of total issuances. So getting through that initial information, how does this break down for our specific industries? And when Msha breaks down statistics for this type of data, for enforcement statistics, they look at both surface and underground, coal and metal non-metal, and metal non-metal, is divided into multiple groups. So that's sand and gravel, stone operations, non-metal and metal operations, as well as facilities, which are looked at differently from the mines themselves. But this first chart shows what the violations, and this chart is actually the top 20. I included the top 10 on our slide to make it a bit easier to read. But the top 10 standards issued in 2016 for surface sand and gravel operations. And looking at those, we probably see some standards that we're quite familiar with. We see that almost 10% of those issued were for 56.14.107A. And most of us are probably familiar with that as being a guarding citation. Now, MSHA's put a lot of emphasis on guarding in the last 5 years or so. They went through new guarding regulations and new guarding phases, but this is still a standard that we see issued very regularly. And it's typically one where the guards are removed for some reason, or they've been damaged in some way. But it is a citation that we see frequently. We can see here it was 10% almost of those issued as sand and gravel operations. We can also see for this specific group, we see that there was 18,000 citations, almost 18,600 issued for 2016. Now, we just saw on the previous slide, going back to 2016, that there was 56,000 issued for the entire metal non-metal industry. So the surface sand and gravel, this is a fairly large amount of the mines in metal non-metal and makes up a good bit of the total citations issued. When we're looking at this, we also want to be looking at, or considering how many of these citations are going to be S&S and how many of these citations are going to be high negligence as opposed to moderate negligence. And obviously that data is not included on these charts, and we could go through a bunch more data to find that out, but it's something to keep in mind that this is just all citations being everything issued under a single standard. So that includes low negligence or reckless disregard. It includes unlikely or occurred incidences, as well as S&S and non-S&S. If we're looking at a surface stone operation, we see that the data is very similar to what we just looked at. The top two standards are just swapped from guarding to the standard on electrical conductors, which we see quite a bit. We also see a standard that should ring a bell as number 3 in both lists, but that is 14100B, 56.14.100B. And this is the defects affecting safety standard. And I point this out specifically because it is also a rules to live by standard, which if we get a significant amount of rules to live by, we can go above our industry average on that, and that can be a trigger for increased enforcement, such as impact inspections or special emphasis inspections. So seeing that standard as a top 3 for these first two should definitely be something that we want to look at. The defects affecting safety standard is a bit of a catch-all for MSHA, and it's something that we're going to talk about a bit later when we look at the individual standards. Next, if we're looking at stone facilities, so different than the mine, but these are going to be the facilities that are largely doing processing in the stone industry. We can see that by and far the most frequently cited standard is that for housekeeping. And again, this is one that, while it's not a rules to live by, it is like the guarding standard, easy to receive because of the dynamic environment that is mining, meaning that there are changing conditions. There can be belts that back up and spill. There can be guards that come off or lead to some spillage. And a lot of times these are going to be issued with higher negligence, depending on how long MSHA believes that the condition existed, or if we're looking at the workplace exams and how those go into effect, that and a citation for housekeeping can play off each other. You know, is Msha going to say that this was something that existed when you came through earlier, or is the record actually reflecting that there was a spillage in that area or some type of housekeeping? We want to keep that in mind when we're looking at it, because these can build up. These are, especially at larger operations, large processing facilities, housekeeping citations can be an area where we see history points build up quickly. And that can be not just the repeat violations per inspection day, not just the violations per inspection day, but the repeat violations per inspection day, so that you're getting multiple violations for housekeeping. And that can turn into higher penalties given how the penalty points are structured in Part 100. So we want to be careful to mind what is happening with those housekeeping citations. They're issued quite a bit, and sometimes they seem to be minor in nature, but Msha doesn't look at them like that, especially if they can find some evidence of exposure to the hazard. And that can also result in the standard or violations of the standard that we see as listed as number 8 on the list, but safe access, or 56.11001. These are often citations that we see issued together or issued interchangeably when one is maybe more appropriate. But safe access violations are also going to be something that's looked at considerably when there is spillage, because what is on the other side of that spillage? Is it a ladder? Is it a piece of machinery that needs to be serviced regularly or inspected regularly? So we want to keep an eye on our housekeeping violations and also the designations of the housekeeping violations. Another set of enforcement data, we see a lot of the same characters here. We see a lot that there has guarding and conductors and housekeeping and the defects affecting safety. The ones that we've just been talking about and building up to, we see those as the top 4. Also, a paperwork violation that is frequently issued, and we sometimes see it even with higher designations of negligence, and the likelihood of an injury, which is not how it should be issued, is 50.30A, which is your quarterly reports. So these get issued enough, or violations for failing to issue the reports or submit the reports on a timely manner are issued frequently enough that they're number 5 on this list for non-metal operations. And when we're looking at those violations, we really want to look at what is Msha asserting the negligence as. What are they asserting, if any, injury? These should not carry an injury. They should be a no likelihood of injury type citation. Especially, we shouldn't be looking at S&Ss. So there's something to keep in mind. Also, the standard below that we see is 56.14132A. And that's going to be horns and backup alarms. And that is one that frequently is discussed and frequently is found, maybe even during a pre-shift exam when Msha's watching, which was the subject of the Wake-Stone decision. And we'll touch on that a bit too. Also on this list, we can see the other guarding citation or other guarding standard for metal non-metal, which is 56.14112B. And when we're looking at the guarding citations, and we'll break it down by the standards a bit more in a few slides, but we want to know whether or not Msha is looking at the guard itself for not being there, or if is it having to do with the construction of the guard, because that allegation is going to determine which standard is appropriately issued. And while Msha might just believe that any guarding standard can apply, that is a nuanced area that we need to look at in terms of contest, and are we getting the correct standards issued, if there is one even valid. We won't break down this data too much, but again, we see the same conditions, we also see a lot of the same standards. One I will note is that number 8 is 14100C, which is different than the defects affecting safety. This is for failure to correct defects. Now 14100 we talked about is kind of a catch-all provision, and that's because it has 4 separate provisions: to do a pre-shift exam, to note defect affecting safety and take it out of service, to correct that defect, and to make a record of it. So that is an area that is going to be looked at, because we are seeing that, you know, if you're stating something or if you're finding something, are you doing anything to correct it, or are you just putting it back into service? And if it is being put back into service, being any piece of equipment with a known defect, that is ripe for higher negligence, for reckless disregard, for 104Ds, for more serious interaction with the agency in terms of enforcement. This is just for the facilities, for metal facilities, and again we see that housekeeping is the main culprit, both provisions of it. So we will, keep moving forward so we can get a more substantive discussion. Lastly, for the surface operations, there is both coal facility and surface coal mines. And like I said, we're not going to talk about these too much because they're majority, or not all of our participants are in the metal non-metal industry from what I could tell. But still, we can see that there are, similar areas of emphasis with the coal industry. And is that going to be, whether it's the first one, which is equipment defects shall be corrected before the equipment is used? Well, that relates directly back to 56.14.100 as B and C, which we were just talking about. The second most cited standard is going to be the accumulations of combustible materials, which we don't see as much in the metal non-metal industry, but is still there. The next one is for quarterly sampling in each work areas, and after that we see examinations of firefighting equipment as well as mobile and stationary equipment shall be maintained in operating condition and shall be removed from service if it is in an unsafe condition. So, while different standards obviously and different types of enforcement, we can see that MSHA's focus in both coal and metal non-metal is really on ensuring, in the top 5 standards that were issued, that equipment is not operated when there is a defect, and that defect is corrected promptly. Now, we probably all know that from our own inspections and from talking with inspectors, but this fails to occur enough that these are some of the most cited standards across all the industry. Likewise, we see the top 5 on coal facilities, surface coal facilities, is essentially a reiteration of the top 5 for the coal mines, with one exception. So, let's talk about how we can avoid these citations. We know that from looking at these charts, the guarding is an issue that arises frequently, and one that MSHA issues more than maybe any other for the metal non-metal industry. And I said that there was an emphasis package going on in the last 5 years for their new phase-outs of guarding phases 1 and 2, which were PowerPoints and included types of permissible and impermissible guarding, what areas need guarded as opposed to all right, without having guarding, being a smooth shaft or a keyed shaft, things of that nature. One area, though, that we look at when we see this is, when does this really come into effect, and how are we going to defend against it if that's the case? I want to point out specifically Part B, and I know that the citation or the most cited standard was actually 14107A, but Type B is an area that, while it's not cited frequently, it is kind of a gotcha standard in that this is the exclusion that if a guarded area is at least 7 feet away from a walking or working surface, if guard is not required. Now I say it's kind of a gotcha for a couple reasons. One is if it were, depending on where it's located, say it's below a tail pulley, is an accumulation of material going to change the height? Because when we installed it or when we determined not to put a guard on it, it might have been a 7-foot or 9-foot distance, but has an accumulation material change that? Also, it begs the question is, what is a walking or working surface? And there's been quite a bit of litigation regarding that. And really it just is going to mean, is it anywhere close to where people can travel? Is it a travel way? Are people going to walk through this in the course of work? Are they going to be performing any function related to work, which could be inspections, or it could be greasing, or it could be anything of that nature? So 14107B is often the standard that we see issued that maybe the case has changed. Maybe there is material there that has now made that 7-foot necessary. Maybe the company didn't think that anything had to happen in this area, yet the inspector witnessed a miner shoveling out something 6 feet away. So this is a citation that, or a standard that we have to keep track of in terms of when we apply it. Typically when we are looking at a guarding standard though, or if we are looking at a citation for a guarding standard, we want to look at what is the exposure. Do miners have any exposure to it? Is the defect significant in that the guard was not on, that there was no guard, or that there was a hole in the guard? And if so, we want to look at, how long was this hurt here? What is the frequency of access to this area of the quarry? Does it happen only when everything is shut down, and other than that, all of our personnel are in equipment? In which case, that really reduces any exposure to the hazards. Or is this an area that is frequently traveled by foot, and that the guard should be in place, but it was removed or knocked off for some reason? We also want to look at there, how long did the condition occur, and do we know that? Was maintenance performed just recently, and that was the reason that now the guard had been removed? Maybe it was removed and failed to be put on, or maybe it was removed and put on and the bolts weren't tightened enough, or whatever attachment point there was didn't hold when the machinery brought back up to operating speeds. And in that case, we should be looking at the other citation, or a citation under the other guarding standard, which is 14112, which is the construction of maintenance of guards. Typically 14107 is when there is damage to a guard and that it is exposing a moving machine part. But again, that's why I say we want to look at how many or how the citations are issued and what specific allegations there are, because that is going to change what we're looking at in terms of our mine history points. If we look at the defects affecting safety standard, which was listed as well on most of those, 56.14.100B, it says that defects on any equipment, machinery, or tools that affect safety shall be corrected in a timely manner to prevent the creation of a hazard to persons. And now I started this and I put down below that this is the rules to live by for the reasons we talked about earlier, that an accumulation of these typically result in higher penalties, are going to be looked at for significant substantial designations, and if we have a number of rules to live by violations, we are going to be subject or reviewed for potential impact or special emphasis program inspections. But the standard itself is more than just finding and correcting the defect. This standard is, again, the catch-all. Msha doesn't have a general duty clause where they can say that this was damaged and we can issue a citation for it. Now, the OSHA general duty clause is much more nuanced than that, but this is as close as Msha has to a catch-all for any defect found on any piece of equipment. And this can be issued for citations to hand tools or to mobile equipment or to processing equipment. And that is really what we want to look at when I say, review these and avoid these. And firstly, we want to make sure that we're completing our pre-shift exams. If any defects are found, we want to make sure that they are addressed promptly so as to avoid any injuries as a result of that defect. Then, we want to also be maintaining our records, and we want to know our record requirements under this. We want to know that our record requirements are that, we need to maintain a record of a pre-shift exam until the defect is corrected, if a defect is found. If no defect is found, we don't need to maintain the record for any length of time. Now, that is what Msha requires. Your company might have different policies on the retention. I will say that if you are retaining pre-shift exam records and there are logs of defects on them, I hope that you are making some additional record or marking it on that pre-shift exam that it was examined and determined either not to be a hazard or it was corrected. Because too many times we see that there could be an issue with a backup alarm that wires are coming loose, and we've repaired it on several occasions, but this continues to occur. If that is the case, but we are not documenting that we have reviewed it or we've looked at it or documented some correcting action, we're lining ourselves up for a situation where we can be getting a defect affecting safety and high negligence or more severe than that because it's continued. And if we're not making note of our corrected action, then it's assumed that no corrective action was taken. Additionally, we want to think about, if we're getting standards under this, is there a more appropriate standard? Are we seeing Msha, is Msha issuing this for a condition that there is more specific standards out there? And I'll bring that up in terms of a strap, so a lifting strap. Often, if there's any defect found on a lifting strap, you see this standard issued. And as we stated before, this standard can also be issued for defects on mobile equipment or a broken handle on a shovel, any range of items. So we want to look at it, and we want to see if there is a standard specific to straps. We should push for that application or the application of that standard in negotiations with Msha or in contest with Msha, because we want to avoid having a buildup of rules to live by violations or any violation under a specific standard, as we said, because we don't want to accumulate those history points, especially with a rules to live by violation. So when we look at these, we want to look at, is there actually a defect affecting safety on it? And then how long was that there? Did we know about it? Did we order parts to fix it already? Is it something that we don't really believe is a hazard because of the operation of the equipment or the way in which the equipment is used? And by that I mean, is it a piece of equipment that's only driven during the daylight, but Msha is saying that the headlight is out? Now, that might not be a get-out-of-jail-free card, but the argument could be made of whether or not it's affecting safety. And it's also something we want to look at in terms of what's going on with the different designations. Another standard that we saw on top of the list was 5612004, and this is for electrical conductors. And I want to focus more so on just the last sentence of the standard, because this is typically where we see the citations issued and where I think the opportunity to avoid them lies. And it is, the conductors exposed to mechanical damage shall be protected. And that really is one where we see damage to extension cords being, or the cord of any piece of machinery or tool being the most cited element. Is there a slice in it? Is there a rub, or is there a burn? Or are we seeing that it's hanging in somewhere near a pinch point, and that it has been pinched previously? When we see these citations or when they come in, oftentimes Msha is, going to be very staunch with them because there is damage. But what I would recommend is, one, we want to look for those types of damage on our extension cords and on the cords of our hand tools, because that's most commonly where these citations are coming from. And if there is any slice, rub, burn, we want to take precaution to either replace or repair it. But also when a citation is issued, or if the inspector brings up they want to issue a citation, we want to look at the condition of it. Is it an area where you can see the inner conductors? If you can see the inner conductors, are they still insulated, or is there damage to that insulation? Or is the cord just damaged in a way that we're starting to see some wear on it, but there is no exposure to the inner conductors? In those situations, I think that we have to gauge the condition of the cord, and each one of you is able to do that, or your personnel are able to do that. But from my perspective, what I'm looking at in terms of a contest is if there is no exposure to the inner conductors, or if the inner conductors are intact without any damage, that's obviously going to affect what designation should be upon a citation. Both in terms of gravity, significant, substantial designations, and obviously negligence is going to come into play as well, but more so for the gravity. And we really want to look at how long have these cords been in that area. Do we have a policy for our individuals to inspect cords prior to use? And do we have replacement cords or alternative tools that they can use in place of these? Because that is what is going to help us mitigate it and avoid these citations. Obviously, to avoid them altogether, we want to, catch these before Msha does, but that's not always going to be the case. So, in terms of mitigation, what steps have we taken to both train our people to avoid them, as well as what mitigation have we done to provide replacements readily? That will go a long way in the S&S designation, especially if something is not in use at that time. Obviously, if a cord is in use, we're going to see a more serious citation depending on the damage that Msha believes exists. Another of the electrical standards we frequently see cited, and we're on most of those lists, is inspection and cover plates. And typically when we see these citations, we want to know, where the cover plate, the damage was, or is there a knockout not in place on a box? And typically when I talk to companies and there's a citation under this standard or an equivalent citation, I frequently hear that an electrician was recently there, or an electrician installed that box, and we haven't been there since because we're not electricians. So even if that's an internal electrician or a contract electrician, unfortunately we didn't install this or we didn't do the work on it is not a defense. It's not an absolute defense. This is, we've talked about this many times before for anyone who's, been on a webinar, but Msha is a strict liability statute, meaning if a condition exists on your mine site or in your facility, you are responsible for the correction or the prevention of that alleged hazard, even if the action is done by a contractor and you did not do it. So with that, I offer that if you are having electrical work done, if you are having any work done on these boxes, make sure you follow up to ensure that everything is in place. Because, while we might not have installed the box, the fact that there is an issue with it is still going to come back on us. Now, we can probably use that towards avoiding, a high negligence, or maybe even getting the negligence down to low on a citation. But, to avoid this standard altogether, we need to inspect the work done by others. So we can't just assume that everyone's going to be doing good work and going to have everything in place. Even those that are very competent electricians, might forget to put a knockout plug in every now and then. But if we do get a citation under this, some areas that we want to look at is, where is the hole located? Is it up around the back of a box that no one ever is going to see unless they're reaching their hand in there? How far are the wires from the opening? Is it even logical to contact them, or is it even a reality that you could contact them without shoving something up in the opening? Also, what is the voltage of the box or the wires going in and out of it? And make sure Msha has that right, because all of these factors are taken into consideration when we're evaluating the gravity or the negligence of a citation. The location and the obviousness of the defect on the cover plate or the box is going to be taken into consideration for negligence. And then the exposure to the hazard is going to be looked at when we're searching for gravity. So, when we want to have work done, when we're going to have work done on our electric, we want to make sure that we're inspecting it afterwards, that we're reviewing what is done. We're not just accepting that it was done correctly, because unfortunately that's not going to get us out of the citation later on. The housekeeping standard we talked about was frequently cited, and there are several provisions of that. Now, most of them listed on the charts we reviewed were under subpart A, which is workplace passageways, storerooms, and service rooms shall be kept clean and orderly. And this is obviously a very broad standard, a very broad regulation, which gets Msha quite a bit of leeway in terms of what is clean and orderly, what is a slip, trip, or fall hazard, and is it really located in a walkway, or could we just move around it? And that typically is where we see most of the contest based under this citation, in areas where maybe Msha says there's a tripping hazard, but it doesn't appear to be, or there was an easy way around it that they just aren't including in their description or their photo of the event. The other two are less cited. Part B we saw in some of the processing facilities is frequently cited because it has to do with wet processes and making sure there is not accumulations of water around frequently. Housekeeping is also, as we talked about earlier, frequently issued in areas where there's spillage. And when we want to look at that and we want to avoid that, obviously spillage should be cleaned or barricaded as soon as practical, as soon as found. And if we can't do that, we need to take some action to prevent access by the employees. We also want to look at how long did something occur. If there was spillage or there was an area that the inspector finds is disorderly, how long was it like that? Do we have any record of that, or was it simply cleaned in the morning and there was a major spillage because a belt stopped in the afternoon, and now it's an hour later and it hasn't been done yet? We want to make these all known to the inspector so that can be taken into consideration. If we have taken steps and we just haven't had it, we've recognized it, we've made note of it, we've tasked someone to go correct it, but they're still finishing up another task, obviously we need to make this known to the inspector. We also want to, again, check after contractors are in an area, because if a contractor's in an area and they leave a mess, we can still be held liable for that. So we want to look at that when people are leaving our site. If we're doing our workplace examinations each shift as required and we're finding spillage, again, we want to make note of where the spillage was, and again, it doesn't have to be on the workplace exam, but we should be making notes somewhere of what action was taken to correct it. Did we send 2 people to shovel off the walk? Because that is going to help to, if it's an ongoing problem that we have an engineer to fix for, are we still addressing it on a daily basis, or is it just showing up on the exams every day with no explanation as to what was done to correct it? So that's, again, a situation where a housekeeping violation can turn much more serious. Now, I'm sure most of us have experienced where Msha finds footprints in a pile of material and gets very excited because now they have an S&S citation, because in their minds, they have proven exposure to the hazard from housekeeping, which again is typically slip, trips, and falls. So, if we do come across a situation where there is spillage and there is footprints through the spillage, we want to look at, how long that spillage was there, why someone would do that, was there anything they were required to see beyond it, was there emergency beyond it, was this an area that in order to effectively clean it, they had to get past it. Now, unfortunately, Msha rarely is going to look at those as absolute offenses, but those are mitigation that we can use to hopefully get off the S&S status. Also, let's make sure that we never do anything as silly as following an inspector as they walk through a pile of material and then turn around and take pictures of footsteps. I know it sounds crazy, but I've heard and I've dealt with cases where that has been the case. So if there is a housekeeping area or a housekeeping hazard, make sure we, one, correct them as soon as we find them, or barricade them until they are corrected. We make note of what we're doing to correct the areas, as well as, if we haven't accessed an area for a length of time, why would we be accessing? What is the frequency and what is the reason for an area being accessed? If it's a remote part of our plant that we only go to once a week, and we only clean it therefore once a week, are we having some type of barrier to prevent inadvertent access, or are we just going to let the inspector know that that's an area that we infrequently access, because that is going to affect the designations if a citation is issued. Lastly, and as we talked about for the metal non-metal surface standards, safe access is one that is typically can be tied to and issued in conjunction even with housekeeping standards, or it can be a standard where they're alternated. So that is, again, a very broad standard that safe means of access shall be provided and maintained to all working places. Now that can mean, that there is something blocking access to a stairway or a ladder or a walkway. It can mean that just there is no constructed safe access for specific areas. But typically, when safe access is issued, it's because of a material spillage in front of a walkway or in front of a ladderway. And I think that it's important that we need to, follow the same recommendations that we just talked about with housekeeping citations, but also this is one where we want to make sure that Msha is actually assessing the right standard or assessing a citation under the right standard. Is this really a housekeeping violation because there was no need to access that area and there's no footprints to prove access, and that the area that Msha is alleging that safe access was blocked from, it was not, because there was another way of entry up there. So I say this as one that we want to look at for and be critical of, does the cited standard apply to our condition? And obviously we want to do everything we can to avoid that citation, but if it is issued, are we applying it, or is it being applied correctly? The next citation or standard I have listed here is horns and backup alarms, and I bring this one up specifically because it can also be issued in conjunction with the defects affecting safety. And it is manually operated horns and devices on self-propelled equipment shall be maintained in a functional condition. And this shall be maintained in a functional condition is an important provision in a case that a few years ago got reviewed by the commission called Wake Stone. And in Wake Stone, an operator had challenged that Msha could not issue citations for conditions found in a pre-shift exam. And in both cases, the conditions in that case were horns and backup alarms. And what Msha found was that maintained means that it has to be in a continuing state of functioning, meaning that the commission found that you cannot have something that is not functioning for it to be maintained. And that's really where this came down to. So, horns and backup alarms can be very problematic pieces on equipment while being integral parts of the safety of them. So we want to make sure that if we are having issues, we are properly documenting them and correcting them and making notes of our correction. As well as if we are getting citations for horns and backup alarms that aren't working on equipment that has been sitting for an extended period of time, we make known to the inspector, one, the last time that it was working. We make note if the horn and backup alarm was working at that last time, and then we are, discerning with what negligence or likelihood and gravity we are going to accept. So, having gone through the surface, we're going to quickly go through some of the charts for the underground operations and talk about a few of the standards there. And then a couple of areas that Msha is looking at as of late. So for underground stone, we can see that we're being under not Part 56 of the 30 CFR now, but Part 57. And the main cited standards, again, we can see are 14100B, 20 or housekeeping, which is at 20003A, and for the most part, the provisions of the Part 57 and Part 56 under the same standards are almost identical in wording. The most cited standard is for ground control and scaling, or the correction of hazardous conditions, and we're going to talk about that one in a bit. But many of the same standards, we see guarding, the same electrical one, as well as a brake standard. Then the underground non-metal, we see again a lot of the very same standards that we've been seeing throughout this in terms of guarding and housekeeping, and the similar electrical ones. Same with underground metal, and underground coal obviously is much different in that we're seeing a much higher number of citations. Comparatively, we see almost 32,000 citations issued for underground coal, as opposed to 18,000 for surface sand and gravel. And we could see that how many more sand and gravel operations there were than coal mines and metal non-metal mines in general. So this is why there still are quite a bit of influence on the enforcement from the coal industry. And when we're looking at this, again, it's going to come back to a lot of similar topics on the coal. So is there combustible materials being accumulated, or what is the ventilation plan, and is that being drafted, submitted, and approved? We're also going to be looking at falls of roof and face and ribs, as well as electrical equipment permissibly used underground. So the majority is going to look at ground control in these top 20, as well as combustible materials, which obviously makes sense in the underground coal industry. But to continue focusing on the metal non-metal, if we're looking at the standard that was most cited for correction of defects, for the underground stone industry, it's 57-3200. And again, as I said, this is a correction of hazardous conditions, which again is a very broad standard. Hazardous conditions can be interpreted broadly, but typically this is looked at for ground control and scaling. And some of the issues we often see with ground control is disagreements between the operations personnel and enforcement personnel with what constitutes a hazard, or whether or not the corrective action taken previously to scale an area was adequate. So what I can tell you in this, in terms of defense, is that we want to look at what the condition was, and is it reasonable that it's considered hazardous. Also, had we made note of the condition, had we done any work to scale it or to inspect it or to monitor it to see if it developed any, and in the meantime we blocked access to that area or blocked access to the exposure. We want to make sure that if there is disagreement with Msha with a condition, before we abate it, we try to fully vet that, because many times what happens in citations like these is the operator says that the condition is not as serious or hazardous as Msha has alleged, and then they require abatement without really trying to figure it out at all, even in terms of during the inspection, blocking access while reviewing it with the inspector, or bringing in someone who did the inspection in the area. We don't ever want to create a greater hazard to abate these citations. Also, if we are doing scaling of any kind, we want to make sure that we, if we're trying to say that this is not a hazard as alleged by Msha, that we're not going to treat it any differently than we typically do. And by that I mean, if we're using the machine that we typically use for scaling, are we, doing it in the same way that we always do, or are we changing our tactics, to get at this alleged condition in a different way? And that can be either applying more pressure with the machine if we're using a machine, or are we using a machine instead of typically scaling something of this nature by hand? In addition to that, we don't want to expose ourselves to another standard while abating one of Msha's, because even if we're in the process of abating a condition that was issued under the previous standard, we can be issued a citation if we expose, or our miners are exposed to, anything during the abatement. And I flag this in particular because this was recently named a rules to live by Msha. So again, it's one that we want to keep in mind. It's also something that we frequently see issued with the previous standard, when maybe you're rushing to try and get a fix on it, and you're rushing to try and get Msha appeased while you're in the process someone is exposing themselves to a fall of material, and that will unfortunately result in a citation. So we want to be sure to maintain our safe practices and procedures even when hoping to abate Msha citations. So some other areas that we're seeing an emphasis aside from these standards is, Msha recently put out an emphasis program on working alone, and in doing so they said they want to now be doing walk and talks regarding working alone with miners. They have put out this PowerPoint including this slide on their suggestions and best practices, and they attribute that to 3 conditions where metal, non-metal, and coal miners in 2017 were fatally injured while Msha says they were working alone. I think this is the one where it's going to be Msha's new task training, and that it is a vague standard, and I think what is interpreted as working alone from a mining perspective could be different from how Msha is enforcing this. I know that one of the fatalities was for an individual who's going to shut off a generator and fail to put a vehicle in park, and they called that a working alone fatality. Another one was a customer truck driver who was dumping a load and got behind that, and they're calling that a working alone fatality. So I think there is some discussion to be had with how it's being interpreted by the agency, but nonetheless, we should be aware of the standard and aware of what it actually requires. So this is the standard on working alone for metal, non-metal, and it says that, I won't have to read the whole thing, but no employee shall be assigned or allowed to perform work alone in an area. And the part I really want to focus on is that second to last line where it says, unless he can communicate with others, can be heard or can be seen. So that's important because, one, it's an or clause, so he can communicate, can be heard, or can be seen. And also, communication, that is something that, typically anyone has, whether it's through CB or radio or, even cell phone. I think the cell phone question is going to be something that we have to work through as an industry with Msha, because I've heard of concerns with whether or not employee cell phones as opposed to a company-issued cell phone is going to matter. But what we have here is one where it says, you shall not be assigned or allowed to work alone unless you can be in communication with others. So, when we're looking at that, it's one that Msha is really going to issue, I imagine, post-incident, where it's easy to say that, if something hadn't occurred here, much like task training with adequacy, well, if something happened, the task training wasn't adequate. This is looking at, if something happened and an individual was with no one else, they were obviously working alone. So it is something to keep an eye on, and you'll be hearing more about it when inspectors are on site. Another area that I can see for increased enforcement is obviously going to be workplace exams. And I don't mean that just because of the new rule that has been finalized and the effective date has been pushed now until July. This new rule and the new provisions of it, I'm sure personnel have said that this is on hold. They're on pause. They don't know what's going to happen with it. They're likely waiting for it to be reviewed and maybe even an assistant secretary of Msha to be put in place. But I think it is still going to be an area of concern, even if we have the new rule thrown out, because of a case decision that came down last year. Now, in this, the Sunbelt Rentals versus Msha, or Msha versus Sunbelt Rentals, the question was, was a contractor at AIR for, failing to catch a defect during a workplace exam? And, the quick synopsis is the trial court judge said that they had completed the exam, and Msha argued that it was not adequate, and the trial court judge said, well, the exam was completed, it does not matter if it was adequate to catch the hazard. So that was appealed to the commission, and the commission found that there was an inherent adequacy requirement with performing a workplace exam, and sent the decision back down to the judge to write a new ruling with their instructions. So that new ruling from the judge has not come out yet, but nonetheless, I think it shows that Msha is going to be looking at, were your exams adequate? Not just were they completed. And I think that should, be something that we have to look at closely, because adequacy is obviously a very subjective term. Whether or not an inspection was adequate, that's going to be largely based on what the inspector believes or what conditions are found after we did an inspection. So if, an inspector might say that something is inadequate because we didn't catch a particular hazard, but that hazard wasn't found until after, or that hazard didn't exist until after the exam was made. So this is an area I think we need to keep an eye on. I'll be sure to update everyone when we get a decision on Sunbelt from the judge again. But the adequacy requirement is, another area of kind of making the rule more vague as opposed to clarifying it, in my opinion. So with that, I know we're butting just over our time frame, so if you want to check out the blog, I would be happy to have you guys check out the materials on there. And like I said, I'll be putting up case decisions such as that Sunbelt rental moving forward. I'm happy to answer any questions at this time, and if anyone wants to reach out to me afterwards, please feel free to. My contact information is on the screen. So thank you very much. All right, doesn't appear we have any questions, so I hope you guys can all join me again on next month's webinar, and if I can be a resource for you in the meantime, please don't hesitate to reach out. Thank you very much. Have a good day.